The Indian Constitution is the largest written constitution of a country in the world. The largest written constitution which is still functional is the Constitution of the state of Alabama in the United States. However, because it is a state constitution, it is generally ignored. The Indian Constitution is only one-third the length of it. But remember, the Indian Constitution is the largest written constitution of a sovereign country in the world. That said, the Constitution of India is the most powerful document in our country. It literally tells us what shall constitute India. The territories of the state and the country are delineated in the Constitution, and the power of the government to change the territory is also provided for by the Constitution. Physical existence aside, the Constitution sets up the three branches of the government that keep our country running. The legislature, which is the law-making body, the executive, which is the law-applying body, and the judiciary. For example, Article 52 of the Constitution says, there shall be a President of India. Without this article, there would be no President of India. The Indian Constitution became fully functional and was enforced on 26th of January 1950. This is why we celebrate 26th January every year as the Republic Day. The date 26th January was significant otherwise too. However, the Constitution was adopted and enacted by the Constituent Assembly on 26 November 1949. The preamble of the Constitution mentions 26 November 1949 as the day we adopt and enact the Constitution. The Constituent Assembly was a mixture of people, a majority of whom were elected to the body, and some were nominated as representatives due to their titles or their jobs. The first meeting of the Constituent Assembly that drafted the Constitution was held on 9th December 1946. In this meeting, the oldest member of the Assembly was appointed as the interim chairman of the Constituent Assembly until a full-time chairman could be appointed. The member was Dr. Sachidanand Sinha. Dr. Rajendra Prasad was elected unanimously as the permanent chairman on 11th December 1946. The Constituent Assembly met in sessions open to the public for 166 days, spread over a period of 2 years, 11 months and 18 days before adopting the Constitution. This is just me giving you context about the Constitution. The purpose of this video is not to discuss the history of the Constitution. The history and the making of the Constitution will be tackled in another video in this module. That said, let us begin with what is Indian Constitution. In its original form, the Indian Constitution consisted of 395 articles spread over 22 parts and 8 schedules. Right now, the Constitution has over 450 articles that are spread over 25 parts, and it also has 12 schedules. The Constitution begins with the Preamble of the Constitution. The Preamble is a statement of purpose. It speaks directly as to the core values that were kept in mind when the Constitution was drafted. The Preamble of India borrows heavily from the objective resolution that was presented to the Constituent Assembly by Jawaharlal Nehru in 1947. This is the reason why drafting of the majority of Constitution is credited to Dr. Bhimrao Ambedkar. However, the creation of the Preamble is credited to Jawaharlal Nehru. The Preamble goes as such. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economical, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Let us break down the Preamble in its components. We, the people of India, having solemnly resolved to constitute India, and in our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. The first and the last statements are the reason why it is said the Constitution gives legitimacy to the functionaries of the government. But the Constitution is ultimately given legitimacy by us, the people of India. The Constituent Assembly is the group of people who drafted and adopted our Constitution. But the Constituent Assembly was elected by the people of India, and therefore it is by the will of the people of India that the Constitution holds its immense power. Constitute India into a sovereign, socialist, secular, democratic republic. In its original form, the preamble only had sovereign, democratic and republic. The words socialist and secular were added by the 42nd Amendment to the Constitution in the year 1976. In addition to adding the words socialist and secular, the 42nd Amendment also added the word integrity to the line fraternity, assuring the dignity of the individual and unity of the nation. The Constitution was adopted and enacted on 26 November 1949. The reason that the Constituent Assembly decided to wait for 26 January to enforce the Constitution is that in early 1930s, 26 January was declared by the Indian National Congress as the day we celebrate as the Independence Day, the day we demand complete independence from British Raj. It was also known as the Purna Swaraj Day. The preamble of the Constitution is used as a tool of interpretation by the Indian courts in various cases. However, the preamble in itself is not binding on anyone. From an exam point of view, it would be best if you know the preamble to the Constitution back and forth. The Constitution of India constitutes India. It sets up the structure of our legislature, judiciary and executive amongst other things. In the creation of the Constitution, the drafting committee under the chairmanship of Dr. Babasaheb Ambedkar looked far and wide for inspiration and learning. India was imperialized for over 1.5 centuries by a country that had unitary nature governance. That is, there was only one major ruling body in the country, the center. The regional ruling bodies were subservient to the center. The power in a unitary form of government emanates from the center. This was well and good for a country that was as small in geographical size as England. However, the geographical boundaries of India were massive. In addition to that, we were also an inherently diverse group of people. A unitary form of government would be impractical to implement. In contrast to a unitary government stands the federal government. Federalism implies that the power is distributed between the governing bodies of the center and the state. In a typical federal government, however, the state is more powerful than the center. The most prolific example of a federal government would be that of the United States of America. The USA was created when separate states came together and decided to form one large country. Theoretically speaking, each state from the United States has the right to secede from the Union and form a country by itself. The separate states that came together decided that it would be in their best interest that certain powers are given to the central government. The rest of the powers were held by the state. In a federal system, the power emanates from the states and is given to the center. In India, a federal system would also be impractical. Keep in mind, this was 1947 when we had 10 to 12 major regional demarcations that were made by the British for the purpose of governance, like the presidencies of Bombay, Bengal, Madras, etc., along with the Northwestern Province, the Punjab Province, etc. These provinces and presidencies were not created to be separate from one another, and therefore they were never independent enough to demand the creation of a federal state. India was always seen as one country rather than 10 to 15 separate provinces. There was no power in the states to give to the center. Keeping this in mind, our constitution gives that we are not a federation, nor are we a unitary form of government. Kenneth Weir, a renowned Australian academician on constitutions of countries that were under British imperialism, called Indian government a quasi-federalism. The Constitution of India also prescribes to the notion of separation of power between the three branches of the government. The legislature is given the ability to make the law, the executive is given the ability to enforce the law, and the judiciary is given the ability to adjudicate upon disputes regarding law. Each organ of the government is given enough power and functions that they stay mostly separate. At the same time, neither organ is allowed to overreach their authority. The legislature is held in check by the judiciary. The executive is held in check by the judiciary as well as the legislature. The judiciary is held in check by the legislature. India, at the center, has a bicameral legislature. This means that we have House of People, also known as the lower house or the Lok Sabha, and we have a Council of State, also known as the upper house or the Rajya Sabha. At present, there are 12 schedules of the Constitution. From an exam point of view, it is important that you know what each of the schedules are regarding. In addition to that, you are also expected to know which schedule after the 8th schedule was inserted by which amendment and in which year. First schedule contains a list of states and union territories and their territories. At present, there are 29 states and 7 union territories. The second schedule deals with the emoluments, allowances, etc. given to the president, the governors of the state and other functionaries of the government. The third schedule deals with the forms of oath and affirmations of various functionaries of the government. The fourth schedule deals with the allocation of seats in the Council of States. The fifth schedule deals with the administration and control of scheduled areas and scheduled tribes. The sixth schedule deals with the administration of tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram. The seventh schedule contains 3 lists: the union list, the state list and the concurrent list. The union list is a list of subjects that the union can legislate on. The state list is the list of subjects on which only the state can create laws. The concurrent list is the list of subjects that both the center and the state may create laws for. The 8th schedule lists the languages recognized by the Constitution. At present, there are 22 languages that are recognized by the Constitution. The 9th schedule was added by the First Amendment Act of 1951. The purpose of the 9th schedule is to reserve laws from judicial scrutiny. The laws listed in the 9th schedule are not reviewable by the judiciary to check for whether they are constitutional or not. The purpose of this schedule was to stop judicial scrutiny in the matters of reallocation of land. While the statutes in 9th schedules still remain safe from judicial scrutiny, the Supreme Court has made it clear that if the Parliament decides to add any more statutes to the 9th schedule, the Supreme Court will not consider such statutes safe from judicial scrutiny. The 10th schedule of the Constitution was added in the year 1985 by the 52nd Amendment. It contains provisions as to the disqualification of members of the legislatures on grounds of defection. The 11th schedule, as added in the year 1993 by the 73rd Amendment, contains provisions regarding village panchayats. The 12th schedule was added in the year 1993 by the 74th Amendment and contains provisions regarding municipalities.